Hello, dear CLAT aspirants. Welcome to the detailed analysis of CLAT 2022 original test paper. There are many videos available where we are analyzing the questions which has appeared in the 2022 CLAT, which is available as a playlist. I request you to watch my previous videos, which will be definitely helpful to give a clear idea how the various areas of CLAT 22 appeared, especially the legal reasoning area. Subscribe to our channel so that you will be getting very valuable information which will help you to prepare for many pan-Indian level, national level exams like SLAT, LSAT, AILET and CLAT. So, today I will be discussing the question number 66 onwards, the 5 questions which came under the category of writ with respect to writ 65 to 70, which probably may be appearing in your test paper as question number from 91 to 95. Okay, according to me, this is probably a very simple area where beforehand preparation would have definitely helped the student to answer this question, because any CLAT aspirant is supposed to go through the writ jurisdiction and the various kind of writs, when and where a writ can be issued, against whom a writ can be issued, and this time it has come as the mandamus writ is being given as the problem statement, which is a very prominent, or rather any CLAT student would have prepared or gone through against whom mandamus can be issued, in what context mandamus can be issued. And according to me, this is a very simple question. All 5 questions, very high chance that you can go correct. On an average, I would suggest 3 to 4 minutes, investing maximum 4 minutes in this to answer these 5 questions is really worth. There is high chance you can go wrong. No confusing questions. Many of the questions are straight. So, any legal reasoning questions, if you are attempting, the basic strategy should be break down the concepts given in the problem statement as simpler points which you can readily recall. Okay, so if you read this passage, based on writ of mandamus, I would suggest you will have to split it into basic points like writ is a public remedy. That is the first point you should keep in mind. There is an existing legal duty on the authority which is supposed to perform, and the duty is a public duty, not a private duty. There is irrationality or procedural impropriety in probably not performing that duty or delaying that duty, or unnecessarily being evasive to fulfilling that duty. So, it is an enforcement of fundamental right which is happening through mandamus. The given statement is about the writ jurisdiction of Article 226 of High Courts, and writ is generally available only if no specific remedy is available otherwise. So, even without looking at the problem statement in detail, there is very high chance that you can answer 2 or 3 questions in this out of this 5 by just having a clear idea as to what mandamus is. If you have prepared, gone through the constitutional aspects, definitely you would have come across through mandamus. So, the questions are very simple. So, as I said, you will have to break up the given problem statement into simple points which you can recall when you go through the questions. So, looking at question number 66, it's a very simple question, because what is being asked by the petitioner? Petitioner is asking to compel the government to grant dearness allowance. Okay, to compel the government. Okay, government made a rule where dearness allowance has been made discretionary whether to give or not. So, it's basic knowledge, we all carry that a writ, you cannot compel a government to formulate a policy or to provide something. So, it's very easy. So, in the given situation, answer A is correct, because writ of mandamus will not be available in this context, because court cannot, there is no legal duty imposed on the government to grant dearness allowance. So, that is why I said if you break the points, the first and foremost thing is there has to be a legal duty. So in this question, government is not carrying a legal duty to give or to provide dearness allowance. So it's very easy to relate if you keep those points very simple. Moving on to question number 67, which may probably appear as 92 in your test paper. Again, if your first question has gone correct, very high chance that this question will be easily, you will be able to answer it very easily, because here also mandamus is being asked to, the government is being asked or rather compelled to formulate a law, which is not actually the objective of mandamus. Okay, what is the question? A public spirited citizen filed a writ seeking a mandamus compelling the government to make a law to curb the ill effects of climatic change. So there is answer B is very clear according to me. If you go through option B and you are very clear, you need not even look at the other options. That is how we are going to save time tracking this exam. Writ of mandamus cannot be granted here, as there is no legal duty imposed on the government to pass a law. So if you look at question number 66 and 67, the principles are the same. You cannot compel if there is no legal duty on part of the government. So these questions you can easily answer. 68, I would say, just by glancing through the question itself you can ask, because A and B are parties to a contract. Immediately you can go for that conclusion. If a contractual remedy is there, there is no question of a writ remedy being applied. So at that point itself, your search should be to find out cannot be granted. That is already fixed. So there are only two options. So even without going through the entire statement, you are very clear there is a breach of contract. As a remedy for breach of contract, writ of mandamus is being prescribed or rather invoked, which is not possible. So the answer is C, because writ of mandamus cannot be granted, as the right under contract is a private right. So it is very specifically given, first word, first sentence itself, writ is a public remedy. So when there are no other alternatives, the last sentence, if you look, the last word given is writ is generally granted in all such cases where the law has not established any specific remedy. So contractual remedy is there. There is no need of invoking writ. Looking at question number 69, which probably would have appeared in your test paper as question number 94. Again, I would say it's a very easy question to understand. This is a classic case where a writ of mandamus can be directed. There is a public duty. There is no latches from the licensing officer. It is specifically given, fulfilled all the conditions. No, the petitioner has fulfilled all the conditions and the licensing authority is not providing the license. In such a situation, this is a classic example. Any student who would have prepared would have gone through this kind of examples where they have done everything on their part. Licensing officer is delaying it. That is where impropriety is there. So answer is A, writ of mandamus can be granted. Here you can compel the licensing officer, but other two questions you cannot compel the government to formulate a law or to come up with a policy. That is not the objective of mandamus. Okay, 70th question or question number 95 probably appearing in your test paper. My friends, this is where unnecessarily most of the students go wrong. The question is, which of the following statement is incorrect? Incorrect. When we get questions where you are asked to find out which is incorrect, most of the time students go wrong. Answer is C, because there you should be very clear. Writ of mandamus, A is correct, B is correct, C is correct, because that is the gist of the problem statement or the explanation given to writ. Option D is absolutely wrong, because if you know the concept of mandamus beforehand, without even reading the given problem statement, you can answer this, because mandamus is issued to compel performance of private duties. Wrong. It is only for public duties. So if you know that distinction, mandamus is not for private duties, it is only for public duties. very clearly you can answer question number 70. So this, according to me, the 5 questions, that block was an easy one. Students would have easily scored over there. We are coming up with more videos where we will be explaining all the other questions. Keep in mind, we are not here to know which is the right answer. We are actually trying to understand how we are going wrong. So if you watch the other videos already available in the playlist, subscribe to our channel. There will be more beneficial videos and information coming to you, which definitely help you to crack premium law school law entrance exams. So keep watching. Thanks a lot. All the best.